Hello and welcome. Once again, thank you very much for joining me in these Katiba reflections with me, Charles Nyachae. You will recall as we have continued to reflect from the onset on the 2010 Constitution, that in the first chapter of the Constitution, the people of Kenya declare their sovereignty. And they then state that they will exercise this sovereignty either directly or through their elected representatives. And in that delegation, as you will recall, the people delegate their legislative power to at the national level to Parliament, and at the county level to the county assemblies. So really, this is the architecture of the Constitution of Kenya 2010 coming together. So today, I would like us to reflect, or to begin to reflect, on Chapter 8 of the Constitution, and this is the chapter that deals with the legislature. It's fairly, as the chapters in the Constitution go, it's a fairly lengthy one. It's also fairly detailed, and in my view, it's a very important chapter of the Constitution. And I therefore propose, as regards our reflections, I propose that we do this chapter 8 in two sessions. Part 1 of chapter 8 deals with the establishment and role of Parliament. Article 93 provides there is established a Parliament of Kenya which shall consist of the National Assembly and the Senate. So our Parliament in Kenya is under this Constitution. It is what is in technical legal terms called bicameral, that is the two houses of Parliament, that are established in Article 93, Subarticle 1. Subarticle 2, the National Assembly and the Senate shall perform their respective functions in accordance with this Constitution. And if I look at the role of Parliament in Article 94, Subarticle 1 provides the legislative authority of the Republic is derived from the people and at the national level is vested in and exercised by Parliament. What I would like to emphasize here is that Parliament is a creature of the Constitution. Many years ago, when I was a law student and I first studied constitutional law, in those days, in many countries, there was a debate, an intellectual debate, on where did supremacy lie, and there was a theory called, at that time, the supremacy of Parliament. Parliament was considered, particularly in the United Kingdom, where really we get the origin of our law, Parliament was considered to be supreme. But in our constitution now, in the 2010 constitution, the supremacy lies not with Parliament, supremacy lies with the constitution, because Parliament is a creature of the constitution. And that's why Article 93, Subarticle 2 says the National Assembly and the Senate shall perform their respective functions in accordance with this constitution. So when we talk about the Parliament of Kenya, we are actually talking about two houses. We are talking about the National Assembly, which we will look at as we go along, and we're also talking about the Senate, and we will see how these, what are the respective constitutional roles of these two houses of Parliament, and how do they relate to each other. What I would like us to bear in mind is that the term Parliament under this constitution refers to both houses and not just the National Assembly, as sometimes there's a temptation to regard it as such. Continuing with the Article 94, Subarticle 2, Parliament manifests the diversity of the nation, represents the will of the people, and exercises their sovereignty. So that is the underpinning basis on which Parliament is established by the Constitution, and particularly to represent the will of people and of the people, and to exercise their sovereignty. Subarticle 3, Parliament may consider and pass amendments to this Constitution and alter county boundaries as provided for in this Constitution. Now, of course, any amendments ultimately for them to take legal effect will be considered and passed by Parliament. But as we will see later, as we continue to reflect on this Constitution, there are different ways of amending the Constitution depending on which part you seek to amend. There are provisions, and we'll say this later, that Parliament can, on its own, pass and amend, but there are provisions which can only be passed through a referenda before then Parliament can carry out that role of effecting the amendment. Subarticle 4, Parliament shall protect this Constitution and promote democratic governance of the Republic. So Parliament has of course, you remember in Article in Article 3 of Chapter 1, the people, all of us, have a constitutional responsibility to promote, protect, and defend the Constitution. Now, in 94, Subarticle 4 here is giving this very weighty mandate to Parliament to protect the Constitution and to promote democratic governance of the Republic. As Article 5, no person or body other than Parliament has the power to make provision having the force of law in Kenya except under authority conferred by this Constitution or by legislation. And Subarticle 6 provides that an act of Parliament or legislation of a county that confers on any state organ, state officer or person the authority to make provision having the force of law in Kenya as contemplated in Clause 5 above, shall expressly specify the purpose and objects for which that authority is conferred, the limits of the authority, the nature and scope of the law that may be made, and the principles and standards applicable to the law made under the authority. So that's a fairly restrictive provision if laws are going to be made pursuant to this constitution by anybody other than Parliament. So, Article 95, we're now looking at the role of the National Assembly. 95.1, the National Assembly represents the people of the constituencies and special interests in the National Assembly. The National Assembly deliberates on and resolves issues of concern to the people. And Article 3, the National Assembly enacts legislation in accordance with Part 4 of this Chapter 8 of the Constitution. Article 4, the National Assembly determines the allocation of national revenue between the levels of government, that is between the national government and the collectivity of the county governments, as provided in Part 4 of Chapter 12. Chapter 12 is the one we will look at later, reflect on it. It's the one that deals with public finance management. B, the National Assembly appropriates funds for expenditure. The National Assembly appropriates funds for expenditure by the national government and other national state organs. So, having determined the allocation between the two levels of government, the National Assembly then has a responsibility to appropriate funds for expenditure by the national government and other national state organs. And very importantly, C, the National Assembly exercises oversight over national revenue and expenditure. That's one of the most important constitutional roles that the National Assembly performs, that is the oversight of expenditure of national revenue. Article 5, the National Assembly reviews the conduct in office of the President, the Deputy President, and other state officers, and initiates the process of removing them from office. This is an important role that the Constitution gives to the National Assembly. This is, for example, as regards the most important constitutional office, that is the President. It is the National Assembly which has the constitutional mandate in terms of to commence the process that is commonly referred to as impeachment, and that is what Article 5 refers to, the process of removing from office. And 5B, the National Assembly exercises oversight of state organs. Article 6, the National Assembly approves declarations of war and extensions of states of emergency. When we come to reflect on the chapter that deals with the executive, we will see the constitutional powers and roles that the president has, and we will then see this interface between what the president can do, particularly in terms of declaration of war and declaring a state of emergency, and the very important role that Parliament and specifically the National Assembly plays in that regard. Article 96 deals with the role of the Senate. 96.1, the Senate represents the counties and serves to protect interests of the counties and their governments. So, in our constitutional architecture, and this was the subject of a lot of debate and discussion in the process of writing the 2010 Constitution. In our constitutional architecture, unlike many countries that are bicameral, in our constitutional architecture, the role of the Senate is fairly restricted. And it is restricted from the very statement or provision in Article 96.1 that the Senate represents the counties and serves to protect the interests of the counties and their government. 96.2 goes on to say the Senate participates in the lawmaking function of Parliament by considering, debating, and approving bills concerning counties, as provided in Articles 109 to 113. So even in terms of legislation, the Senate is restricted to bills concerning counties, and we will see what are these bills concerning counties. I think the broad thing to understand is the background and the process of making this constitution. There was clearly those who were involved in the process clearly wanted to ensure that in terms of the constitutional mandate that is given respectively to the two houses of parliament, the National Assembly had or is given a broader mandate, and the Senate is given a more restrictive mandate. I do not want to get into the debate from time to time has been there, which is the upper house, which is let's just stick to the position that each House of Parliament has been given a very specific mandate by the Constitution. Article 96, Sub-Article 3, the Senate determines the allocation of national revenue among counties as provided in Article 217. Again, 217 is in the chapter 12 that deals with public finance management, and exercises oversight over national revenue allocated to the county government. So, in terms of public finances, the determination of how, when you look at the provisions that I have looked at in the last few minutes, the broad picture that the Constitution creates is that in terms of the division of the public revenue between the two levels of government, that determination is ultimately, there's a process, but that determination is ultimately by the National Assembly. Now, the division that is thereby given to the county governments as a collective is then allocated by the Senate between the counties themselves. So there are two distinct roles that the two houses of parliament have in terms of the national revenue, and firstly division, and secondly allocation between the counties themselves. Sub-Article 4, the Senate participates in the oversight of state officers, considering and determining any resolution to remove the president or deputy president from office in accordance with Article 145. I stated a few minutes ago that, for example, if the president or the deputy president is to be removed from office, that process is initiated by the National Assembly, but it is determined by the Senate. So actually, this is probably, at least theoretically, this is probably the most important, for lack of a better word, or the most powerful role that the Constitution gives the Senate. If a president is or deputy president is to be impeached, that final determination will be made by the Senate. Part 2 of this chapter 8, composition and membership of Parliament. Now, membership of the National Assembly, Article 97. The National Assembly consists of 290 members, each elected by the registered voters of single-member constituencies. So these are the constituencies as we know them, that each elect a member of the National Assembly. They are 290. So that's the first and perhaps the major category of membership of the National Assembly. Secondly, 47 women, and I emphasize women because I've had discussions where people ask me that these women representatives, where does it say that they must be women? The Constitution is very clear. This is an affirmative action provision, and it provides that 47, this is the second category of membership of the National Assembly. 47 women, each elected by the registered voters of the counties, each county constituting a single member constituency. So for this second category, for the 47 women, their single member constituency is the county. And then 97 1C, the third category is 12 members nominated by parliamentary political parties according to the proportion of members of the National Assembly, in accordance with Article 90, to represent special interests, including the youths, persons with disabilities, and workers. Now, you will remember in our earlier reflection on Chapter 7, that is representation of the people, when dealing with the elections, there is a process whereby those to be nominated to Parliament, and in this case we're talking about the National Assembly, there is the political parties give to the electoral management body, IEBC, they give a list prior to the election from which IEBC will then name nominees to the National Assembly based on the proportion the respective parliamentary political parties will have gotten in the just concluded election. Number 4, in terms of the membership of the National Assembly, is the Speaker, who is an ex-officio member. So the Speaker is actually a member of the National Assembly, but ex-officio by virtue of being Speaker. But as we continue, we will see there are limitations other than presiding over the House. There are limitations in terms of voting. The Speaker is excluded. 98, membership of the Senate. The Senate consists, 47 members, each elected by the registered voters of the counties, each county constituting a single member constituency. So, like there are the women elected under 97 1B, here again, the constituency becomes, the county becomes a constituency, and each county elects one senator, member of the Senate. B, again, an affirmative action provision, one of the major ones in the Constitution. B, 16 women members who shall be nominated by political parties according to their proportion of members of the Senate elected under Clause A in accordance with Article 90. Again, here, the political parties will give the electoral management body a list that contains, for purposes of 98 1B, this one contains only women because it is an affirmative action just for women who will be who the parties will nominate, and who will the becoming members of the Senate will depend on the proportion which the particular political party will have achieved in terms of the then just concluded election. C, 2 members being 1 man and 1 woman representing the youth. D, 2 members being 1 man and 1 woman representing persons with disabilities. And again, here, finally, the Speaker, who shall be an ex-officio member. So if you count all those, then the Senate then has 67 members. That is the 47 elected by each county, the 16 women nominated, and then the two members representing the youth, the 2 members representing the disability. All those are 67. If you add the Speaker, then the number of members of the Senate becomes 68. Sabbatical 2, the members referred to in Clause 1C and D shall be elected. That is the 2 representing the youth and representing the persons with disabilities, shall be elected in accordance with Article 90. We looked at Article 90 earlier on, and these are those nominated, the lists given to IBC prior to an election. Article 99, qualifications and disqualifications for election as a member of Parliament. Now, this Article 99 deals with member of either house or both houses, National Assembly and the Senate. 99 provides that unless disqualified under Clause 2, a person is eligible for election as a member of parliament if that person is is registered as a voter, B, satisfies any educational, moral, and ethical requirements prescribed by this constitution or by an act of parliament. So here we are talking, you remember we reflected on chapter 6 of the constitution, and as well as the enabling legislation, which is the Leadership and Integrity Act. So a person is eligible by satisfying that particular criteria in Article 99, 1 subarticle B. A C is nominated by a political party or is an independent candidate who is supported by, in the case of election to the National Assembly, by at least 1,000 registered voters in the constituency, or in the case of election to the Senate, at least 2,000 registered voters in the county. I believe we looked at this particular provision when we were looking at representation of the people in chapter 7. So that is the third qualification. So you are either nominated by a political party or you are an independent candidate who complies with the provisions of the Constitution. Subarticle 2 of 99, a person is disqualified from being elected a member of parliament if the person is A, a state officer or other public officer other than a member of parliament. I think that is fairly self-explanatory. B, a person is disqualified if the person has, at any time within the 5 years immediately preceding the date of the election, held office as a member of the Independent Electoral and Boundaries Commission. So if you've been a member of IEBC, then within 5 years of an election, you cannot be qualified to be elected as a member of parliament. C, again, disqualification if the person has not been a citizen of Kenya for at least 10 years immediately preceding the date of an election. So that if you have, of course, this wouldn't apply to citizens by birth, but if you have acquired your citizenship in another way, then from the date you acquire that citizenship, for a period of 10 years, you cannot be elected as a member of parliament. D, if disqualification if the person is a member of the county assembly. E, if the person is of unsound mind. F, if the person is an undischarged bankrupt. G, if the person is subject to a sentence of imprisonment of at least 6 months as at the date of registration as a candidate or as at the date of election. So if somebody has been sentenced for, say, 3 months, they would not be disqualified. But if it is at least 6 months, then they would be disqualified under this provision, 99(2)(g). H, very important, if the person, they're disqualified if the person, in accordance with any law, is found to have misused or abused a state office or public office or in any way contravened Chapter 6. Now, this is very important, but must be read with the following provision, which is sabbatical 3, which states a person is not disqualified under clause 2 unless all possibility of appeal or review of the relevant sentence or decision has been exhausted. So if you have, for example, been sentenced to 5 years in imprisonment by a magistrate's court, you still have processes where you can appeal or have that decision reviewed. So under this provision, you would not be disqualified from being elected. Article 100 provides for Parliament enacting legislation to promote representation in Parliament of women, persons with disabilities, youth, ethnic and other minorities, as well as marginalized communities. Election of members of Parliament, Article 101. Sabbatical 1, a general election of members of Parliament shall be held on the second Tuesday in August in every 5th year. I think that provision is fairly well known because under the we've now had 3 elections under the 2010 Constitution. Although the first one, obviously, the court had to determine it when the first one would be held, but the next two, 2017 and 2022, were held in accordance with Article 101, Sabbatical 1. Under that Article 101, there are provisions relating to when a vacancy occurs to the different categories of members of Parliament, so that where it is a person who has been nominated and a vacancy occurs, then the Speaker gives notice in writing to IEBC and also to the political party that had nominated that person. And then that vacancy has to be filled within 21 days. Now, Sabbatical 4 is an interesting one in current circumstances because this relates to the vacancies that arise in the National Assembly, where the Speaker, in either House of Parliament, where the Speaker is required within 21 days of the occurrence of that vacancy to give notice to IEB in writing to of that vacancy to IEBC, and then, and this is why I say it's interesting in current circumstances. 101(4) Sabbatical 5. In those circumstances, the Constitution states a by-election shall be held within 90 days of the occurrence of the vacancy, subject to Clause 5. Clause 5 just states that if this happens within 3 months of an election which is about to take place, then you don't have to have a by-election. But Sabbatical 4B is very clear that a by-election should be held within 90 days of the occurrence of the vacancy. The reason I said it's an interesting one to reflect on in current circumstances, because there has vacancies have arisen in the current parliament, at least I know there was a member of parliament who was run over by a vehicle and he was killed. That is many months ago. So, strictly speaking, if you are applying sabbatical 4 of Article 101, the Speaker is required to, within 21 days of the occurrence of that vacancy, to give notice in writing to IEBC. And 4 sabbatical 4B states in imperative terms, a by-election shall be held within 90 days of the occurrence of the vacancy. Now, we have this situation where we do not have members of IEBC. Therefore, it is not possible to comply with Article 101 4B. But I just put it out there for a reflection. Perhaps the courts may guide on how that kind of situation is to be dealt with. 102 deals with the term of parliament. The term of each House of Parliament expires on the date of the next general elections. And the sabbatical 2, when Kenya is at war, Parliament may, by resolution supported by each House, in each House by at least 2/3 of all members of the House, from time to time extend the term of Parliament by not more than 6 months at a time. And sabbatical 3, the term of Parliament shall not be extended under clause 2 for a total of more than 12 months. So what that means is that if Kenya is at war, then both houses can resolve by a 2/3 majority to extend the term of Parliament, if necessary, for 6 months, and then another 6 months. So the logical conclusion would be, after the 12 months, you must have an election. That's how I read it. But, that's just my reading. Vacation of office of Member of Parliament, Article 103. The office of Member of Parliament becomes vacant, A, if the member dies, B, if during the session of Parliament the member is absent from 8 sittings of the relevant House without permission in writing from the Speaker, and is unable to offer a satisfactory explanation for the absence to a relevant committee. B, the member is otherwise removed from office under this Constitution or legislation enacted under Article 80. That's the legislation that deals with leadership and integrity under Chapter 6. D, if the member resigns from Parliament in writing to the Speaker. Now, E is very interesting and is also current in a sense. E, if having been elected to Parliament, 1, as a member of a political party, the member resigns from that party or is deemed to have resigned from the party as determined in accordance with the legislation contemplated in Clause 2, or as an independent candidate, the member joins a political party. Now, obviously, we have this situation where these issues have arisen as regards 103 E Roman 1, and particularly member being deemed to have resigned from the party. Yes, I am sure that the courts will give guidance on this. F, at the end of the term of the relevant House, or if the member becomes disqualified for election to Parliament under Article 99. That's the list that we looked at earlier for disqualifications. Now, this constitution and in this chapter, and specifically Article 104, has what is possibly a unique provision, which is the right of the people to recall their member of parliament. And 104 Sabbatical 1, the electorate under Articles 97 and 98 have the right to recall a member of parliament representing their constituency before the end of the term of the relevant House of Parliament. Sabbatical 2 says Parliament shall enact legislation to provide for the grounds on which a member may be recalled and the procedures to be followed. This is a fairly unique and, on the face of it, theoretically a radical provision. But in practice, the legislation that has been put in place and again was recently, I think it was either last year, amended is such that it's almost impossible. The constitutional provision is there, but it is almost impossible in practice to recall a member of parliament. I hold the view, by the way, that this provision to recall a member of parliament, and these are reflections, so I'm just stating my view. I hold the view that apart from it not being very practical, I'm not sure of its necessity, because if the people have elected a member of parliament and it's their choice, and this person has not otherwise violated the constitution so that they may be disqualified or lose that position, I'm not personally persuaded that there is a basis on which a member of parliament should be recalled simply because the people have had a change of heart. And that's probably why the legislation is the way it is, the way it is, and virtually impossible to have practical effect. But that's my view, and it's one of those that perhaps should be reflected on. Article 105 makes provisions that touches on determination of questions of membership of parliament. 105.1, the High Court shall hear and determine any question whether A, a person has been validly elected as a member of parliament, or B, the seat of a member has become vacant. Article 2, a question under clause 1 shall be heard and determined within 6 months of the date of lodging the petition. I think I will stop there for this part of the reflection on Chapter 8 of the Constitution. As we will have seen, befitting the position of the legislature in the architecture of our Constitution, Chapter 8 is fairly detailed, but I think when we reflect on the remaining part of Chapter 8, I think at the end of that is when I will perhaps make some concluding reflections as relates to the chapter in its entirety. For now, I thank you very much, and I look forward to further engagement on reflection of Chapter 8 of the Constitution of Kenya, 2010. Thank you very much.